What's up? Please. All right. Hello, everybody. My name is Dylan Palmer. I am the Executive Vice President here at the Duke Law Federalist Society. I hope that you're all having a great semester. This is our last speaker event of the semester. It's our last one, yeah.
But not least, huh?
So I hope you've all enjoyed our programming this year. The Federalist Society is a nonpartisan educational organization founded on the principles that the state exists to preserve freedom, the separation of governmental powers is central to our Constitution, and that it is emphatically the duty and province of the judiciary to say what law is, not what it should be. All expressions of opinion are those of our speaker. And now for a little bit about our speaker. Professor Josh Blackman is a professor of law in the Centennial Chair of Constitutional Law at the South Texas College of Law, Houston, where he studies and teaches on constitutional law, the U.S. Supreme Court, and the intersection of law and technology. Before joining the South Texas College of Law, Professor Blackman launched Fantasy SCOTUS, a United States Supreme Court prediction market, and maintained a personal blog recognized by the ABA as a top 100 law blog. After law school, Professor Blackman clerked for Judge Gibson on the Western District of Pennsylvania and for Judge Boggs on the Sixth Circuit Court of Appeals. Professor Blackman took his undergraduate degree from Penn State and his law degree from George Mason Law School. I will now hand it over to Professor Blackman. Please join me in welcoming him.
Thank you so much. My goal today is to make everyone angry, and I will try. Most debates about judicial reform are predictable and pointless. Progressives, they're unhappy with the current court, and they want to make it harder for conservatives to win in court. Conservatives are happy with the current courts, and they want to make it harder for liberals to prevail. Okay, so everyone kind of has opposite incentives. Proposals which only help one side have a slim chance of enactment. Indeed, efforts to address judicial emergencies by creating new judgeships often stall. Why? To avoid granting a windfall of appointments to a single president. Any changes to the court must be bilateral. We cannot have unilateral disarmament. So today I will give you 10 proposals, 10, that will equally weaken both the right and the left. These proposals don't need to be adopted as a package. They can be adopted piecemeal or mix and match, right? Like Chick-fil-A, nuggets, fries, whatever you want. You can mix and match these. Most of these can be done through a statutory amendment. Some can be achieved by the courts themselves. I am agnostic about which is better. I prefer if courts self-regulate, but if Congress has to do it, so be it. Now, I will admit up front, I'll be honest, that some of these proposals are kind of off the wall and mostly meant to stimulate debate. This is not a concrete action plan. In fact, I think that some of these proposals will actually create problems about judicial independence and the separation of powers. But I think they pass muster even if they exist in a gray zone. There are three primary values that inform my proposal. First, there's a sharp decline in how many cases the Supreme Court is hearing. That undermines the court's primary role, resolving circuit splits and promoting uniformity of federal law. The justices are deciding fewer cases, while the lower courts are divided. Last year, barely 60 merits cases. They're not working hard enough. It's true. Second, the justices are cloistered. They are insular. They are insulated from the lower courts and the American people. And frankly, they stay in the job way too long. I'm not proposing retirement ages, but they should retire earlier. But they have no incentive to. They have cushy jobs, smart law clerks. They're just worshipped when they go out in the public. We gotta get rid of that stuff. Okay. Third, there's a lot of expedited litigation on the so-called shadow docket or the emergency docket. And this creates a lot of confusion, it wastes resources, and forces judges to make decisions under tight time constraints. There are proposals to curb forum shopping, eliminate national injunctions, but that just treats the symptoms and not the underlying illness. Okay, so I think court watchers all stripes will agree with these three principles. Okay, now I'm going to list my 10 proposals. Then I'll go into more depth in a few moments. Okay, the first two proposals are about the Supreme Court justices themselves. Okay, number one, ready? Number one, Bring back circuit riding. Require the justices to ride circuit. When? When the federal courts of appeals sit en banc, the circuit justice presides. Ooh, I like that one. Okay, number 2, they're making way too much money. These justices get $1 million book deals, no more. So impose statutory caps for outside income through book royalties, advances. They want to stay in the job till they're 90 years old, let them earn their government salary for 90 years. Okay. The second grouping focuses on the Supreme Court's docket. Number 3, ready for this one? We all work year-round. They should too. So mandate the Supreme Court sits in session year-round with at least one sitting per calendar month. No more summer break. No more going to Stroudsburg. They stay in the swamp. Unless they go somewhere else. Number 4, establish a standard timeline for reviewing petitions and applications in the merits, emergency, and capital dockets. Congress has power to decide when cases are decided. Number 5, the Supreme Court actually has a mandatory jurisdiction. Any case in the mandatory jurisdiction must be argued. They can't just scoff it off. Okay. The next 5 proposals focus on litigation in the lower courts, but this matters to the Supreme Court. Number 6, cases seeking a TRO, a temporary restraining order, can be decided by a single district court judge, but relief is limited to the named parties for no more than 7 days. Limit TROs to 7 days. Okay. By the way, I wrote this last year before all the stuff going on now, so this is not. I didn't make this for the current world, but it still works. Number 7, if you're seeking a preliminary injunction against a federal government or a state government, it goes right to the en banc court, which appoints a randomly drawn 3-judge panel, but 2 circuit judges, 1 district court judge. You skip district court proceedings altogether for PIs. Just go right to the circuit. Okay. Proposal 8's a bit in the weeds, but I'll read it to you clearly. Injunctions of statutes against the federal and state governments are automatically stayed. So if there's ever a time where a court enjoins a statute, it's automatically stayed. If the 3-judge panel is divided, as 2 judges go one way, the other judge goes the other way, there's what's called a certificate of division. That case goes to the Supreme Court's mandatory review, mandatory jurisdiction. They have to decide it right away. So if the lower court's divided, it goes right to the Supreme Court. No more 3 years to decide an issue. Okay, number 9. En banc circuit courts and state Supreme Courts can mandate the Supreme Court will take a case. How? What's called a certificate of split. If a circuit court certifies that there's actually a circuit split in an issue, mandatory review. No more lawyers lying about circuit splits and cert petitions. We're done with that. That doesn't matter. And what I call a certificate of importance. If the lower court says this is a very important issue, please decide it, mandatory review. Number 10, this one will be controversial for the lower court judges. When a judge hits what's called the rule of 80, that is, they have at least 65 years of age and 15 years of federal service, what's called the rule of 80, they are basically taken off the en banc court and new judgeship is created. They keep the Article 3 commission, but they don't sit in the en banc court. Okay, ready? Let's walk through this. Okay, so I think my first proposal is actually pretty popular. That is, I require the justices to ride circuit and preside when federal courts of appeals sit en banc. Now, for those who don't know, maybe foreign students, before we had our current system of courts, the Supreme Court judges would call ride circuit. They would actually sit in lower courts throughout the nation. They would hold trials. They would actually hear cases. This was abolished in the late 1800s, early 1900s, because it was viewed as too much work for the justices. Back then, there were horses and buggies, there were trains. It was very hard to get around. It was considered too much work. I would bring this custom back. As it stands now, the Supreme Court judges are what are called circuit judges. So, for example, we are in North Carolina. This is the 4th Circuit. The Chief Justice, John Roberts, is your circuit justice. So any emergencies from this court are appealed to actually the Chief Justice in the first instance. Okay? But I would give them more work. When the en banc courts, when the courts of appeals sit en banc, that is, the entire court sits together, out of the circuit justice preside over that. There's a lot of benefits here. First off, it changes the composition of the circuit court, right? Usually the circuit court composition is predictable. You know who's on the left, who's on the right. But having Supreme Court justice comes in, alters that map. Also, it lets the justice see how is law being made on the ground, what's actually going on in the world. Let them talk to these judges. Maybe they'll get a different sense of how law should be developed. And oh, by the way, I would rotate the circuit justices. As it stands now, the Chief Justice always has the DC Circuit and Fourth Circuit. Why? Because John Marshall did it, right? Rotate, right? Sotomayor is always in the Second Circuit. Let it come down to Texas. We welcome her, right? Let Justice Thomas go up to Maine once in a while, right? See what's going on in Boston, right? Shuffle around. That way the justices can see everything in this country. It's not fair that Justice Kagan always has the Ninth Circuit and Alito has the Fifth Circuit. Why? Right? There's too much power. So every year would rotate, even have like a little bingo game, right? They put their hand into a little jar and pick out a number, right? Which circuit you get, make it random. This way, all the justices would get a sense of what's going on in the world. Now, is this constitutional? I think so. I think at least Stewart versus Laird, a very important decision. More or less appellate circuit riding. I say we bring it back. Okay, my second proposal gets a bit controversial, but I don't think it should. If anyone here who work for the federal government, U.S. attorney or offices or PD, right? There are limits on the ability of federal employees to earn outside income. They're actually fairly strict limits. And if you are a federal judge, you also have a limit. Now, you might have some judges who teach here and elsewhere, right? They're allowed to teach. It's one of the few things judges can do. And there's a cap. It's about $30,000 a year that they're allowed to earn. I don't object to that. That's a cap. That makes sense. People should be compensated for their time. But there's an exception. Royalties. Royalties are exempt. So you may not know this, but when a justice gets a book deal, they basically get what's called an advance on their royalties. In other words, the publisher says, we are giving you, Justice Barrett, Justice Jackson, Justice Sotomayor, $2 million in advance because we anticipate your book will make $2 million in royalties. And you get to keep that money. And if it takes 30 years for you to sell that many books, that's fine. This is what we call in business an interest-free loan, right? Where you're giving money to someone who might never pay it back. And I assure you, if they don't pay that money back, it'll never be collected. They'll wait till the person dies. Maybe their estate can collect it, right? Paying these massive $1 million royalty advances is simply a way of getting around the cap on outside income. I have actually researched this. The origin of this is actually sort of benign. Imagine you're an inventor and you have a patent, and the patent generates royalties every year. You become a federal judge. Good. You feel to accrue the royalties from your patent. I think that makes absolute sense. But when you're a justice and you cash in with this massive book deal, when you saw it, you should be getting all this money. So I would put the $30,000 cap to book royalties. If you want to be paid $30,000 for a book, God bless you. Right? Good for you. Right? We academics, we write books, we don't get paid very much at all. Justice Barrett never wrote a book when she was a law professor, but with the justice, $2 million. Took her 4 years to write the book. I still haven't seen it. Right? So I would impose the $30,000 cap on there. Okay. Proposal number 3. The justices will sit year-round. The justices follow a pretty predictable schedule, right? There's a statute that says they meet starting the first Monday in October, right? That's a statute, right? It could be any day. And the justices should hear cases between October, and they stop hearing cases in April, maybe late April. And then by the end of June or early July, all their cases are decided. And then really July, August, September, they're sort of off for the summer. That's a nice lifestyle, right? To have the entire summer off. But it often happens that emergencies arise over the summer. And the justices will not hear argument. They've only heard argument in September once, maybe it's 15 years ago in the Citizens United case. They heard Cooper v. Aaron in September, maybe 50 years ago. They do not sit over the summer. This summer, I think their vacation's getting ruined. Just to preview things to come. There are too many emergencies arising. I would make them sit year-round. Have at least one session per calendar month. And this is not just about oral arguments, it's also about the conference. Now, this goes sort of into the weeds. But to get a petition granted is very hard at the court. Right? The court grants a very small number of cases. What happens to all the petitions that pile up over the summer that are filed in June, July, and August, right? They're heard at a specific conference called the Long Conference, which is usually at the end of September. Like, there are hundreds of petitions to this Long Conference that's built up. Can I tell you something? The grant rate at the long conference is very low. It's a very low grant rate. So lawyers have a strategy. If you're the petitioner, you want to get considered before the long conference. And if you're the respondent, you want to delay, push it to the long conference. All this strategery, right, that goes on. I would have a conference every month and avoid the sort of rush here. All right. Proposal number 4 is more controversial. I would establish a timeline for review of petitions and applications in the merit, emergency, and capital dockets. As things stand now, the justices have complete discretion over when and how to decide cases. You can have a cert petition that sits in the docket for an entire year. I'm not exaggerating. They keep relisting it, then granting it. With the emergency docket cases, the justices don't always use the same timeline. So I'll give you an example. Just this week, there was a case involving Tren de Aragua, right? A deportation of these alien enemies, right? Go to this prison in El Salvador. The Chief Justice demanded a response within 24 hours. Wow. Government files petition, response 24 hours later. We also had a birthright citizenship application. How much time did the Chief Justice require? A 3-week response time. So why is it one case in the emergency docket 3 weeks, another case is 24 hours? It's obviously based on the court's own sense of what's important. I think that's a little bit too much subjectivity. I think the court should have a standard timeline of when things ought to be due. And we can argue over what these timelines are, but there should be a timeline. And just to show them, I'm not only talking about the right, I mean the left as well. Death penalty cases. This is an area that's almost, how to describe it? It's a race to the execution, right? Where there's a warrant signed saying you must execute this person by such and such date and time. So the government's rushing to get this as quickly as possible. And obviously the prisoner, the defendant saying, no, please slow down, right? Have these various appeals and the like. And often get to the court where the execution warrant expires at midnight. And the Supreme Court issues a ruling like 11:58, right? Or 11:55. Right before midnight, and they say, okay, go ahead and execute the guy. By that point, it's too late. They can't even do it because all these delays have happened. I think that's no way to run a railroad. So I would have fairly standard timelines of how much in advance a capital case must be filed by the court. And if the lower courts know this timeline, the lower courts can move with appropriate pacing, right? This idea of having rulings, 11:55 p.m. with a midnight execution, that's no way to run a court. Okay. Proposal number 5 might seem a little bit wonky, but actually it makes some sense. Most of the court's dock is what's called discretionary, right? They can grant certiorari. There are still some mandatory jurisdiction cases. I think should be expanded, but there's still some now. For example, certain campaign finance cases, cases involving voting rights. In other words, the court has to take it. But do you know what they do that's kind of quirky? The court doesn't actually schedule oral argument. They'll just say, we affirm the lower court with a 1-sentence opinion. No. I'm sorry. If Congress says these cases are mandatory, that means you at least give it an oral argument to actually consider it, not to dispense of it in such a summary fashion. I would mandate that these so-called mandatory cases go through oral argument. Okay. Let's go on now to proposal number 6. Okay. Proposal number 6 involves temporary restraining orders. Again, I wrote this paper last year, so all the stuff in the news I didn't know about. District court judges under my rule can issue TROs, but relief is limited to the named parties, and they last no more than 7 days in duration. Okay, so there's 2 facets there. First, they cannot issue national relief. That is what's called a non-party injunction. They can only issue relief to the people who are before them, both the government agents on the defendant's side and the named plaintiffs before them. Okay? We do not want judges issuing national relief. Also limited to 7 days. We've had in this regime of the current pace of litigation, TROs have lasted almost a month before they get to a court of appeals or the Supreme Court. I think it doesn't work. You need to have these more short-term duration ones to get it up. My 7th proposal focuses on preliminary injunction. Just to sort of explain the difference, if you haven't done the procedure, a temporary restraining order is often granted without much briefing, without any oral argument, just sort of maintain the status quo. It's limited in duration to some limited period, a couple weeks or so. A preliminary injunction is a more permanent form of temporary relief. Sounds like an oxymoron, right? I have permanent temporary relief. It lasts for months, maybe even years, but it's an injunction that's in place until there's a final judgment, whether it's a trial or otherwise. Okay, so preliminary injunctions last longer, but I would change the way PIs are granted. Now, maybe you might know this. In the earlier parts of the 20th century, when there's a challenge to a federal state law, the case was brought before what's called a three-judge panel. A three-judge panel. This is a panel of 2 federal district court judges and 1 federal circuit court of appeal judge. And at that point, there was mandatory review to the U.S. Supreme Court. So that ensured that any sort of constitutional challenge would get to the Supreme Court very quickly. Congress got rid of that in the 60s and 70s. They thought this was a bad idea. We don't want to have it anymore. I think we need to make three-judge panels great again. I think we need to bring this back to the front, but in a particular way. When you seek preliminary relief against a federal or state government, what happens is the case goes to the en banc court, and the en banc court randomly draws a three-judge panel. Now, very careful. It's not the chief judge who draws a three-judge panel. Under the current regime, you may not know this, the chief judge is very powerful. They get to draw the three-judge panels. Why? Because they're the oldest? I think it's way too much power. I mean, I adore my chief judge in Fifth Circuit. I think she's very smart. She shouldn't have this authority. Your judge definitely shouldn't have this authority in the Fourth Circuit, right? No one person should have all that power. And I can just say in the Fifth Circuit, we will have a run of about 40 years straight with Republican chief judges. Like, I've done the math. The next Democratic chief judge of the Fifth Circuit probably still in law school, right? Or maybe in elementary school, I don't know. On the Ninth Circuit, likewise, we have 30-something years as a Republican chief judge. So there's way too much power. The en banc court can randomly draw. The other shift to have is it's 2 circuit, 1 district. Why? Almost all these PI matters are really questions of law. The facts don't really matter anymore. These are legal questions, right? What's the scope of the Alien Enemies Act? What sort of processes due to aliens being deported? What does birthright citizenship mean? Right? These are legal questions. So I'll have just 3 judges, 2 circuit, 1 district court judge. And they would need to decide this on a fairly expedited basis. Now, if all 3 of the judges agree, then it becomes a regular case. It can be appealed through certiorari. But, right, this is where number 8 comes in. If the panel is divided, that it goes 2-1, that means this is an issue of division. They can certify the case to the Supreme Court. Again, so if the preliminary injunction, if it's a 3-judge panel, if they divide 2-1, that's mandatory review by the U.S. Supreme Court. Mandatory review. They have to take it. And have to decide it on an emergency docket timeline. That ensures that there's some new statute enacted by the federal government or the state government, it goes to the Supreme Court right away. This is a much better way of doing things than what we currently have, where it can take years for statutes to resolve. I mean, the Affordable Care Act, for example, right? This is a very important piece of legislation enacted in 2010. The Supreme Court didn't uphold it until 2012. It took 2 full years to resolve it as this law is being implemented. There was actually a proposal wasn't passed that would have given the Supreme Court mandatory review of the Affordable Care Act. They didn't put that in the bill. I would have this feature much more prominently to side. Okay. Number 9, moving along very nicely. Okay. I would give more power to the en banc courts and the state Supreme Courts. If you ever read a cert petition, there's always a section, right? Why should this petition be granted? And they will always say there's a circuit split. They say 2 things. It's a wide circuit split and it's a deep circuit split, whatever that means, right? That there are many circuits that have had this conflict, but also they deeply, profoundly disagree with why there's a split. Okay. The other side says, no, there's not, right? There's not a split, right? They're exaggerating it, right? The actual issue here is different. The circuit's not really divided, and the division's superficial. They have all these sort of buzzwords to sort of minimize it. So you have this sort of game where one side exaggerates the split, And the other side trivializes the split. And that's fine. That's advocacy. Don't believe any of them. If any of you are clerking at the Supreme Court, maybe one of you one day, you will learn to become very skeptical when you read these briefs because there are lawyers being paid a lot of money and they're representing their clients zealously. And they're going to exaggerate the case to try and get it granted. It actually happens, though. This happened a couple of times where the court will grant the case and they realize, wait a minute, the thing we granted is not what we had. The case is different, right? You sold it to us one way and now it looks a little bit different. So let's dismiss the case as granted improvidently. This happens every now and then. That's an embarrassment. So I would shift the burden. Instead of having lawyers just lie about it, whether there's a circuit split, let's have the judges decide it. If the judges of the en banc court certify that there's a split, that's good enough for me. If the judges of a state Supreme Court certify that there's a split, that's good enough for me. That when there's a case that comes with this certificate, it's a mandatory appeal. The court has to take it. We don't have to worry about lawyers lying about whether there's a split or not. Just ask the judges. And so someone says, well, Josh, won't the judges lie also? Okay, maybe, right? It's possible. I have a little bit more faith in federal and state Supreme Court judges to accurately describe the state of the law, but maybe they're lying. Okay, so maybe is it a majority of the Supreme Court of the state Supreme Court? Is it a supermajority? I don't know. We can toy with the metrics, right? What the numbers are, but I would create a mechanism by which the state Supreme Courts and the courts of appeals can certify a case, but not just for a split. There's also something called a certificate of importance. This one's a little bit trickier, right? Let's say there's some new issue that hasn't had time to percolate a split yet, but it's really significant and really warrants the court's attention. That should also be something they certify to the court. So instead of having a top down with the Supreme Court sort of like God, it's kind of like a trickle up where all the lower courts can actually exert pressure on the Supreme Court. You're inverting the hierarchy to let the Supreme Court have less control of their discretion over their docket. I think that would be very healthy. Okay, almost done. I'm at number 10. Number 10 concerns the Rule of 80. And maybe you're not familiar with the Rule of 80. The Rule of 80 is a way that judges can take senior status. Senior status is a form of semi-retired judging where you keep your salary, you keep your Article 3 judgeship, but you don't have the same caseload as others, right? You can have a reduced docket. On the Federal Court of Appeals, when you take a senior status, you don't sit in the en banc court. That's kind of the biggest deficit. On the trial court, you can say, oh, I only want criminal cases, I only want civil cases. You kind of limit your docket. When are you eligible for the Rule of 80? It's a combination of your age and your years of service. So you have to be at least 65 years old. That's when the retirement starts. If you're 65 years old and you've been a judge for 15 years, 65 plus 15, that's 80. Okay, that means you can take senior status. Let's say you're 70 years old, right? And you now have 10 years of service. Okay, 70 plus 10, that's 80. So the math works different ways. Let's say that you're 50 years old, you've been a judge for 15 years. Nope, not yet. You have to be 65. Okay. But eventually you get to the Rule of 80. We know it's going to happen. It's like, we will all die one day. We will all just get the Rule of 80 one day. So when you hit the Rule of 80, something happens. Number one, you are taken off the en banc court. I don't think that there's a Article 3 problem there. People don't like when I say this, but there's no constitutional requirement they sit in the en banc court. I don't think you have that. But what does happen is a new judgeship is created, which Congress can then fill through presidential nomination. Why is this significant? There's a problem. Well, I don't know if it's not a problem, but it happens, where judges strategically time their senior status. It's a known fact that Republican-appointed judges wait for Republican president to take senior status. And it's a known fact that Democratic-appointed judges wait for a Democratic president to take senior status. Don't fight me on this. It's true, right? Look at all the people who took senior status with Trump and with Biden. The numbers line up. Now, for Trump, I would say he got lucky, but a couple of Democratic judges died. They died. They're waiting out. So Trump filled those seats, like Stephen Reinhardt. He did not give up his seat willingly. He gave it up by the great beyond. Funny that Stephen Reinhardt still decided cases after he died, but then the Supreme Court said you can't do that. So I would eliminate the power of judges to sort of manipulate this. Another thing that's kind of malicious, judges say to the president, I will take senior status if you pick my law clerk as my replacement. This actually happens. Judges will request that their successor be picked. And it actually happened with one judge during the Trump years where Trump picked someone else. And the judge said, never mind. I'm going to withdraw my senior status request. Eventually, he died and he didn't get his pick. So don't toy with these things. So I would get rid of this. The judge, when they hit the rule of 80, they're off. That also create opportunities for new members of the judiciary. I do not want all these 80-year-olds being judges. I mean, I love people, their grandparents alike, but eventually you can slow down a bit. It'll happen to all of us, I promise. Okay, so let me wrap up. So this project of bilateral judicial reform is equal parts ambitious and naive. I admit that. I appreciate that my 10 ideas are likely to go nowhere. You know, it's a bit of a Festivus vibe, if you will. I just air my grievances and move on. I don't pretend I've worked out all the kinks or these are even practicable, but I'm trying to think a little bit outside the box and put these ideas into the ether that might coalesce into actually a tangible proposal. Now, there's a foreseeable consequence here, right? So first off, if we expand mandatory jurisdiction and have more or arguments, the case's docket will increase. Back in the 1980s, the Supreme Court decided 200 cases a year. We're down to about 60 now. I think 200 would probably be about what we'd be looking at. So they'd have to go back to the old things. So, but if the court in the 80s with no computers and no internet could do it, they do it now. Trust me, they can do it. Now, the common proposal for reform is court expansion, right? And they say, well, Josh, with 200 cases, they can have more justices. Well, maybe, but also maybe the justices could, travel less, write fewer books, focus on their jobs, work 12 months of the year, maybe shrink argument time. You don't need to have like 4 hours for a case. That's insane. Stop writing all these separate opinions that I have to read and teach about. These 50 pages dissent from denial certiorari, stop those. And look, if the work is too tough for the justices, someone else will take your seat very easily. There's a line from here to the swamp. People who become a Supreme Court justice. It's very long. I think Congress could also increase their pensions, make it more enticing to step down. But this can be done. After all, judges have a life tenure and not a life sentence. Thank you so much for your attention. Welcome your questions. Yeah. Sure, either one. You're sitting next to each other.
Okay. Thank you so much for being here. I know you mentioned briefly actually at the end about the life tenure, but I noticed some of your proposals try to create incentives for judges to quit sooner.
Yeah.
I'm curious why that's preferable to just instituting like a requirement or restriction on the amount of years they can serve.
Right. So to be clear, I think a mandatory retirement age would require an amendment to the Constitution. I don't think you do it by statute. So I have mixed thoughts on mandatory retirement. I can talk about that in a moment. But what I would do here is simply make it less desirable to be a justice later in your life. And I think that will be effective at retirement age, right? If they're deciding only 50-something cases a year and they're only sitting for 8, 9, 10 months of the year, they can travel. So they can just push it out, right? They can hang out. In terms of do I support a retirement age, I think the wrinkle there is we would actually have justices with incentives perhaps to misbehave as getting close to the retirement age. So in other words, if a justice knows they're retiring in a certain year, whatever sort of constraints they may have, it's like, all right, whatever. I'm thinking ahead to my next job. How do I appeal to the most people, right? I think it perverts the incentives. So David Strass was a judge in the 8th Circuit, wrote this back when he was a law professor. I think he's actually persuaded me. He said favorite term once I changed my mind. So I don't know that I favor them, whether it's 18 years or otherwise. I would just make it that if you can't do the job, you should probably step down. That's what I would leave it as. Very good question. Yes.
Could you explain sort of like the counterintuitive shift from 200 plus case docket to 60 now, and how that figures into some of the solutions that you're proposing? Like, what's the reason for such a decrease?
Right. There's a million sort of theories about why the numbers decreased. It hasn't happened all at once. It sort of happened gradually. I think part of it is the Supreme Court bar has gotten a lot better, and they become much better at identifying which cases are the best vehicles. And this sort of breeds a skepticism when the clerks think, okay, we want these perfect vehicles, these perfect cases, and that decreases the number. But that doesn't explain all of it. There are a lot of what I would call bread and butter circuit splits, like in criminal procedure issues. They're not ideological, right? different types of searches, different technologies, right? Splits have been around for years on different jurisdictional points. The court just seems less interested in taking these cases. And I don't know if it's the clerks in the cert pool or the justices. I think on the current court, Justice Barrett's most cert shy. She's least willing to take cases. I think she wants things to percolate more. But even things percolate, they don't take it. I think Justice Thomas is most cert curious of the court and willing to take as many cases as he wishes. We have a lot of these sort of dissents. One other demise is these something called the joint four. That is, if 3 justices vote to grant cert, O'Connor was known to say, I will give a complimentary fourth. In other words, even if O'Connor didn't want to take the case, if 3 of her colleagues have that, O'Connor will give a fourth to grant certiorari. That's dead. No one in the court gets a joint 4. So I think that decreases a lot. So you have a lot of these cases with 3 judges dissenting. I mean, if one justice said, I will bring up the joint 4, I think we're up to 80, 90 cases right away. That's just that would just be the cases where people are dissenting on. Good question. Yes, sir.
Thank you so much for being here. I had a little bit more of a question on the number of cases. So specifically, some of your points target both circuit writing and increasing the volume. Are those perhaps mutually exclusive? Because we get to about 200 cases, it's going to be much more difficult to write circuits. I'm just curious to hear your thoughts on that.
Oh yeah, yeah. I mean, look. So again, my proposal, I say, you don't have all of them, right? Right. So if it actually gets to the point where they're deciding 200 cases again, we might pare back the circuit writing responsibilities. Again, that's why we killed them initially, because when the court really abolished circuit writing, they were deciding like 300-400 cases a year, right? I mean, and they did this without word processing, without law clerks, and there were a lot like 89-page dissents, the opinions. They were just short opinions. So I'd be okay if we actually were able to get to the point of deciding more cases. Then they don't need to resolve the lower court stuff. I think that we can relax. Yeah. Yes.
So it seems like one thing that's affecting the judiciary right now is just kind of the need to step into more politically incredibly sensitive cases. Do your proposals, are you just seeing, is this more like a good governance idea to basically make it more efficient so the court can decide these questions? Or is there also a vision like, maybe let's try and get the court to step back and deciding all these incredibly hot button political issues?
I would want the court to decide bread and butter circuit splits. In other words, they're going to decide like the abortion case and the gun case and the birthright citizen. They're going to decide the big stuff. I'm talking about the regular boring, the security case, right? How do you interpret various issues of personal jurisdiction, like boring stuff that real lawyers, you all in a couple of years, will be dealing with. Those are the cases that are festering. I read every week the court issues an order list. I go through every single entry and I usually check what are the cases being denied. And I see these petitions where it's like, there's a 15-year circuit split on this issue. Please, for the love of God, grant cert. Denied. Like, what the hell are you waiting for? What do you want to do? And it's not an ideological case. This week, almost a 9-0 reversal or 9-0 affirms, but just pick a side. Just pick something and then make that the rule. Yes, ma'am.
Yeah, thank you so much for this. It's really interesting. I think a lot of the suggestions make a lot of intuitive sense and feel pretty safe, like page 1, 2, 3, and 10.
Oh, you kept track. Good for you. I don't remember the numbers.
I'm curious about maybe like some potential unintended consequences of some of these. I think in particular, I was curious about the like limiting TROs to 7 days and not issuing like national relief, and then also the timeline requirements for emergency dockets.
Oh, yeah. I mean, to be clear, I think there are unintended consequences for a lot of these. What I think would invariably happen, though, is if the district courts are limited to 7 days, and I have a lot of sort of nuance of how this works in practice, the Supreme Court would have to get involved earlier. And I think we're seeing this now on the court. There was an aversion, and Justice Jackson makes this point, saying we shouldn't be deciding these cases on this bare-bone briefing on an expedited basis. But the fact is, lower courts are doing just that. So I think the court will have to decide things much quicker. And frankly, I'm not opposed to that. A lot of these issues are issues meant for the Supreme Court. To use an example just from this week was the removal of the members of the National Labor Relations Board, the NLRB, right? A 3-judge panel in the DC Circuit said that Trump could remove them. And then a couple of days later, the en banc DC Circuit reversed and said, no, let's set this for briefing. And then Judge Henderson had a dissent saying, why are we wasting our time? Only the Supreme Court can decide this. We're just delaying the inevitable, right? So I would, unfortunately, if there's issues of national significance, just have it go to the court quickly, which to my friend's point over there, it gives a court a lot more work on a short timeline. So then maybe you don't have to go circuit riding, right? So I think we're going to see, by the putting a step back, the shadow docket is going to break, right? The Supreme Court cannot keep this pace of these massive issues decided with that oral argument. They're not able to do it. We're already, April 8th. By May or June this year, they're going to be probably like 4 or 5 or 6 huge cases in the docket on top of the regular June cases. I don't say they're going to summer break this year. I just don't see how it's going to work. They can't just let the country say, okay, we're going to Salzburg, enjoy yourselves, bon voyage, right? I don't see they're going to do this. By the way, this Justice Kennedy went to Salzburg. No one goes there anymore. That was his home for the summer. What other questions? Yes, go there in the hat.
Yeah, a quick question. You mentioned that we used to have the 3-judge panels until the 70s-ish. I'm curious why, if you know, Congress decided we weren't going to do that anymore. Why we moved away from that? With the 2 circuit judges in the district.
I've looked into this and I've not seen a clear answer. I think the short answer is the Supreme Court didn't want mandatory jurisdiction. I think the Supreme Court pushed back to have more control of its docket. I think they said they were being flooded with too many cases that were not worth their time. So the reason why I wrinkle it is it only goes to the court if there's division. That is, if this is an issue which people can disagree upon. And that ensures not being hit with frivolous appeals. There's, if this is a statute that's clearly constitutional and all 3 judges agree, then you don't have to take mandatory appeal. But I've not seen a clear good reason why it was abolished other than the court wanted more control over its docket. I think the 3-judge panel approach worked well enough. I mean, also think about it this way: judges have a lot of stuff on their docket. It distracts from other cases, so maybe it takes away from criminal cases. Right? It is distracting, right? When judges are put on an emergency panel, it's a fire drill, and they have to stop whatever they're doing, focus on the stuff. I can see why they wouldn't want to do this, but the judges are doing this now. The D.C. Circuit, poor judges Henderson, Walker, and Millett, right? They had all these huge cases the last month because they were just on call for that week when everything came up. Yes.
Can you speak more to the normative benefits that are guiding these proposals? Like, it seems like we want the Supreme Court to take more cases. We might want justices and judges to be a bit younger by incentivizing older judges and justices to retire. What are, I guess, the more of the normative benefits that follow from these proposals?
So for one of my overarching goals, and this may sound crass, is I'm trying to reduce the cult of the Supreme Court. I think they get too full of themselves. I think they sit in their cloistered chambers. They don't see real people, normal people, and they sort of forget what the world is. This would make them go out. This is why I like the circuit riding. They have to go out and see other people, right? Justice Sotomayor can come down to the Fifth Circuit. Justice Alito spends some time in San Francisco. That's good, right? I think there's actually a healthy benefit. By giving them more work, I think it's sort of a stress test. Can they actually handle it? I think, some justices, Justice Blackmun, not no relation, I think Justice Stevens, a few others, stayed on past their prime, but they were not doing their best work later in their careers. It became obvious when they would read stuff. But I think now it'll become obvious earlier if they're able to keep up with the workload, right? They'll know these cases aren't being decided on a timely basis. I also think, and this is, again, sort of crass, but I'll say it, we all age, right? We have infirmities, and not everyone. Some people in their 90s are as sharp as ever. You meet these people, it's remarkable. Other people, they start going downhill. They don't always see it. If we're able to create new judgeships, whenever this rule of 80 is triggered, you can always have new crops of people coming into the judiciary, and there's less of a stigma for judges to retire, right? If the judge is sick and they say, oh, I think I can get better, maybe they're a senior status, they don't have to worry about that. It sort of takes care of itself. So that's sort of the normative justifications. I respect the work that senior judges do without question, but my thinking is that if there's less of a stigma of taking senior status, more than we'll stay around longer. Other questions we have? Yes, over there.
I think some of your proposals, and correct me if I'm wrong, they sort of already would, where they play off of existing functions and sort of systems. So I'm curious if you, looking at your proposals, have you kind of gotten any sort of rough figure on if you were to implement some of them, what the increase in caseload would be?
Oh, that's a good question. I have no idea.
No.
It's a really good empirical question. I have no clue. I've tried to sort of just kind of back the envelope calculations. And if you just sort of look at how many cases each year where low courts are screaming circuit split, it's not in the hundreds, but it's in the dozens, right? So at least those would be mandatory review. If you add in all the cases where lower courts are issuing injunctions against statutes, oh my God, last year was one thing. Now it's insane. Maybe now it's several more dozen, right? So, maybe 100 more cases a year, 200. It's not a crazy number. That's kind of a back the envelope calculation, but I don't have anything clear. It's a good idea, though. But they should, 60 is way too low. Just the number of cases they're deciding is just sort of stunning. How many they're granting like 1 or 2 cases per conference. They used to grant like 7. Back in the day when I was in law school, they would have arguments 2 in the morning and 1 in the afternoon. They don't do that anymore. They have 2 in the morning, they go home for the day, right? They've not had an afternoon argument in some time, maybe a couple, but very few. What else? Yes.
I'm just curious, if you start accelerating some of these decisions or like adding more into it, do you think that might take away from some of like the thoughtfulness behind these arguments and could maybe make for some quote unquote bad law?
Okay, it's a fair point. So the thinking is when the justices have more time to deliberate, they can make better law. That's a proposition that's contestable. I think sometimes there's benefit to having a clearer rule that can be decided quickly than perhaps a better rule that might take years to develop, right? There's always a debate in law about certainty versus fairness. You always have these sort of competing goals. I would, in many cases, rather have a certain rule than a rule that's perfect, that comes some years later. Most practicing lawyers would probably agree. Now, let me be cynical for a minute. The justices, when they have years to think about it, don't always do a great job. How many opinions are in your case books that, what's the holding? What do we do with this? More time doesn't always yield better law. It also generates concurrences in judgment, right? Fractured opinions. Sometimes back in the day, back in the early 1900s, they didn't have time to dissent. They said, all right, whatever, I'll just join. I don't have time, whatever, it's fine. We'll move on to the next one. That's not a bad thing, right? Sometimes just don't dissent and then whatever, you deal with it later. Yes, sir.
It's hard to kind of ignore the feasibility of a lot of these policies when listening to them. Do you have any insight into how we could expect a legislature,
They won't.
50% of whom think that Supreme Court's doing a great job, or even a court to accept these reforms that would limit the amount of money that they can make and make the work a lot greater?
Yeah, I said I was naive. I meant that. I'm not that naive. I know that these are unlikely to be passed. I mean, I've talked to members of Congress. I've talked to different think tanks, and these are like 1 or 2 of my ideas. What I think would be ideal is if the Supreme Court took it upon itself to do these things. I think a lot of these the court could do. I mean, nothing would stop the Supreme Court from saying, we want to ride circuit again, right? Chief Justice Rehnquist famously, or infamously, sat in a trial court in Virginia. He was actually reversed by the Fourth Circuit, where he apparently did a terrible job. He never did it again. But that's the problem. He did it once, and they never did it again, and then they gave up. Why can't the Supreme Court justices go back to circuit riding on their own? They don't need permission, right? Why couldn't a justice say, I will voluntarily donate my royalties to the U.S. Treasury? To the Holmes devise, right? Justice Holmes had a devise of money donated to the government. They don't need Congress. I mean, if the Supreme Court said, if we find that a circuit court says there's a split, we're going to grant cert, they could do that tomorrow, right? They don't need permission. So almost all these ideas can be done on their own. Local courts could adopt rules saying TROs can only last for 7 days and are binding to the parties. I think a local court could adopt that rule. They could do that. So it'd be nice if Congress acts. I'm not stupid. I know it's probably not going to happen. But I think that I think it could be done. What are the questions?
I had a question about, I guess, your certificate of importance.
Yeah.
At least on the state side. So I think states state Supreme Courts have different interests, I think, than those that are nationally recognized. I don't think that's in dispute. I'm curious if there's sort of a vetting process for that, because it feels to me like that could be a position where we're inflating the court's numbers sort of unnecessarily. So,
Yeah.
like, what is the metric for importance? I feel like most people think the work they do is important. So
I think, right, no, I know that one's probably the most prone to abuse, and I'd be happy to back off of it. I think what I'm trying to get at is there are sometimes issues that are novel that might take some years to percolate, but require prompt resolution. So imagine some sort of new a federal law that's sort of enacted, and it's not subject to a preliminary injunction, but it's very significant. Think of the Affordable Care Act or something, right? The state judges might say, take this now. Now, your point, the state judges are often elected. I'm in North Carolina at the moment. I know you have an election dispute at the moment, right? Maybe they're not considered as venerable as federal judges. I didn't want to do that. I think it's a little bit arrogant. I think a lot of state judges work very hard. They do their job as best they can. I wouldn't treat them as second, subordinates, right? They are, what was it? Martin versus Hunters. Let's see. They're next up, right? We don't need federal courts, just the story tells us. We could have had no federal courts at all. So I would give them the same respect I would give to the federal circuit courts, but I can see people might disagree on that one. Other questions we have? Yes, sir.
I am curious, in the context of state Supreme Courts, what sort of cases do you think that they would then certify for importance? Because presumably their wheelhouse is state constitution.
I think there are probably fewer, right? If it's an issue of adequate and independent state law grounds, I can't imagine it's important for the Supreme Court. Maybe like a Fourth Amendment issue, maybe some sort of federal constitutional law issue, maybe a preemption issue, right? I think that the universe of those cases in the state courts is probably a little bit less.
Thank you all for your fantastic questions. Please join me in thanking our speaker.
Thank you so much. Thank you so much.